Founded in 1965, Temple LLP is one of the leading litigation law firms in Canada. Based in Toronto, they specialise in providing services to corporations, associations, institutions, insurers and, of course, their policyholders. Their hard work has resulted in a reputation of being experts who are able to deliver excellent results and exceptional service to their clients. Well, today I'm delighted to say that I'm joined in the studio by the partner Katherine Kolnhofer. Thank you so much for joining us. I get the feeling that I've just touched on the tip of the iceberg in terms of what you guys do.
Yes, we have experienced trial counsel that deal with multi-party complex litigation in numerous areas of commercial and insurance-related areas. We pride ourselves in our innovation, and we've developed a technology law group that specializes in cybersecurity and privacy law, in addition to drone law. And we provide consulting services and legal advice to different organizations to prepare for cybersecurity potential breaches on a preventative basis, and in the event of a breach, on how to deal with a breach. In addition, we've explored the upcoming area of drones, where there's an intersection with cybersecurity potentially, and privacy issues, as drones are being used to in e-commerce or corporate commercial ventures to transport goods and materials or sensitive information. And the Canadian regulatory bodies are currently looking at expanding drone regulations as well, in terms of approvals and permits and interactions with the aviation system. And so our technology law group is focused on those two areas and being at the forefront and developing a niche practice for our clients and being experts in the area.
Because just to put this into context, you are chair of the firm's Privacy, Cybersecurity and Technology Law Group, but just give us a sense of context. What is the current state of the cybersecurity climate in Canada? Because it is a big issue, not just in Canada, but globally.
Yes, it is. Canadian organizations have not updated or adapted to the increasing cybersecurity threats and attacks that are proliferating the globe, as many organizations in different nations as well. And so the Canadian regulatory bodies are attempting to address concerns that the citizens have, the public have, as to how their personal information is being protected and whether it is being properly protected by these organizations that are somewhat resistant to infusing capital into their infrastructure and just, are still of the view that this is not going to happen to us, so we don't need to concern ourselves. And so the Canadian regulatory body has initiated regulations that will be implemented in the fall of 2018, which impose mandatory breach notification requirements. And this is designed to enforce accountability and transparency for the business community and organizations that deal with the public's personal information. And the regulatory body, in addition, is concerned about Canada's adequacy standing in the global community. So currently Canada does have adequacy standing in how they deal with personal information, but with the impetus of the GDPR, it is important that Canada come up to the same standards as the US, for example, or the EU, as is coming in at the end of May, and ensure that the Canadian protections are on par with that, so that global economy and the markets continue to want to interact with Canadian businesses on a similar level. And so the breach notification regulations that are coming into place in the fall will have numerous components. One is notification to individuals whose personal information has been breached. And in those situations, the organization is required to report to the Privacy Commissioner and the individual if a breach results in a real and significant risk of harm, potentially, if it's reasonable to believe that such a risk of harm would be caused by the breach to the individual. And in such circumstances, notification is required to be as soon as feasible. Now, there is some subjectivity to the regulation, which can potentially cause issues for organizations, in that they will have to interpret what is a real significant risk of harm, and the regulations do provide some guidance in that regard. One of which is to determine the sensitivity of the information. So in conducting a risk impact assessment, they'll have to take a look at the sensitivity of the information and the probability that it may be misused in determining whether that meets that threshold for notification. Importantly as well, the government has imposed mandatory record keeping requirements so that organizations are required to log all data breaches, not just the ones that require notification.
Or hit the headlines.
Yes, correct. They will be required to keep those records for a minimum of 2 years, and the Privacy Commissioner will have the authority to do on-the-spot audits or investigations of organizations to ensure that they are record keeping, and also to review the records to ensure that the breaches that are recorded were adequately dealt with and complied with the regulations, and that risk impact assessments were conducted to determine whether notification was required. So the concerns are, in terms of the record keeping and the onerous requirements, are that organizations will be exposed potentially to further litigation or investigation should the Privacy Commissioner take a look at the past records and determine that prior breaches were not properly handled. And so this enforces the accountability and transparency aspect of the regulations. And so organizations do need to be concerned that they are properly complying with these requirements.
So these are very comprehensive ideas which have been put forward there by the government. And you were talking there about the GDPR, which is the General Data Protection Regulation, comes into force in the EU on May the 25th. Do you feel that in some ways that initiative has really forced the cyber community in Canada to really sit up and take notice? I mean, this is clearly what you've been saying to them, but this has really given you the message, some extra push. Is that a fair point to make?
Yes, it's an excellent point, actually. I think the GDPR internationally is being held out as a sort of gold standard on the most rigorous privacy protection at the moment. And so, yes, it was definitely an impetus, as are the US regulations, in regard that Canada had to step up, and in order to ensure that it doesn't affect the relationships or the economy between the countries, to assist the organizations in being up to par with the international standards.
And as you said earlier as well, there's a very good business case for really making sure that companies get their security up to par. But I mean, what preventative measures can they take to prepare for data breaches? Because we know these things do happen. The recent problems with Facebook and Cambridge Analytica demonstrated that.
Yes, so the key to preventative measures are seeking out the expertise, the appropriate expertise, and that would include legal counsel to provide advice to companies on a consulting basis to formulate a risk management strategy. So every organization should have a risk management strategy that incorporates a number of components, which includes preparing an incident response plan should a data breach occur. Some of the examples that we've seen in the media have been organizations that have been, despite their significant size and sophistication and involvement in the technology community, have been somewhat caught off guard, didn't expect it to happen to them, and they were grossly mishandled, which led to significant reputational loss, business interruption, and loss of confidence by the public in those services. And so that could have all been avoided with appropriate preventative steps. Now, part of a risk management strategy is not only engaging legal counsel, but IT professionals. And often the IT professionals that organizations have in-house are sometimes not equipped to understand or deal with some of the cyber threats that are external. And so it is important often to retain a third-party IT company that is plugged into the community. There's some sharing of information among certain industries about what types of malware is out there, or what types of threats or attacks the criminals or nation states are engaging in. And so that sharing of information is crucial. And so retaining a third-party forensics company or IT company to assist in doing things like penetration testing or war games, which are simulated attacks in the organization, and the personnel and employees are required to follow what should be an incident response plan that's in place to test it out. It helps them plug in the gaps and patch the holes in the system. What's also very important is to have a company-wide culture of cybersecurity. And previously, some of the concerns that came to the forefront in some of those larger organizations that were exposed in the media were that the executives or the C-suite was not actively involved in the cybersecurity strategy of the company. They deemed it to be the responsibility of the IT professional and often would blame the IT professional and didn't take responsibility. And so cybersecurity, there needs to be a holistic approach. It needs to be a culture throughout the entire organization.
It's everybody's responsibility, basically.
It is. And there has to be leadership buy-in, because if the leadership hasn't bought into the culture, then the remaining employees or personnel haven't bought in either. And so personnel training is also critical from a prevention perspective.
Sure. So as you said, that's how you prevent something like this happening. But of course, a company can be caught off its guard because we know that hackers are pretty persistent as well. So how can a company mitigate the impact of a security breach?
Again, if there is a data security breach, that unfortunately does happen, and we know that it is not a matter of if, but when. The statistics show that most organizations, if not all, will at some point suffer a breach of data or a ransomware attack within the organization. And in many situations, the hackers have lived in the system for a number of months undetected. And so that can cause differing levels of damage to the company and difficulty recovering. And so the mitigation strategies, again, are following your incident response plan. And another critical important aspect of the prevention is to obtain cyber insurance. And what's important about cyber insurance is most of the policies include a data breach management team, which the insurance company will offer to you the minute there's a breach. You are able to invoke those services of these vetted professionals that include a panel of legal counsel who are familiar with how to handle the data breach, and forensic IT professionals that will become immediately involved, assess the damage, assess how to stop the damage, mitigate the damage, and either restore information or negotiate with the ransomware attacker, etc. And so those services that the insurance provides are critical to the mitigation aspect. There have been situations where corporations either haven't had the insurance or they didn't want to invoke the insurance and have attempted to deal with it themselves with their internal IT professionals who really are not, they're good at their jobs, but this isn't their specialty.
It takes it to a new level, really, doesn't it?
It does. And I've often made things worse by either expanding the malware accidentally or not taking the appropriate steps to go offline, etc. And so it's very important to engage that data breach team immediately. And a PR consultant is also very important, often part of the breach team, who will assist you with your how you put out the message to your consumers, clients, whoever it is whose information has been compromised, to mitigate the reputational damage. And of course, legal counsel to ensure that you're meeting the regulatory compliance rules for notification and record keeping.
I mean, Bell Temple is really well placed. I mean, you've come into this obviously at the right time. You can see the pitfalls and the way ahead. But in terms of the broader impact of the GDPR for Canada, where do you see that taking the country, and at what point will it have to be revised? Because again, there is this war of attrition between the legislation on the one hand and the persistence of the hackers. They're constantly raising the game.
Yes, so the GDPR, as I noted before, is I think being touted as the gold standard. And there are some aspects to the GDPR that are more stringent than the Canadian regulations. For example, there's a lot of buzz and talk about the penalties that the GDPR imposes in the case of non-compliance. In the most extreme of cases, the supervisory authority has the authority to levy a fine of up to 20 million euros or 4% of the annual turnover of the company, whichever is the largest. And that would apply to a Canadian organization should it breach the regulations as well. And so that should be of significant concern. In addition, the notification requirements are slightly different or more particular. The organization must report to the supervisory authority in the event that there is a risk to the rights and freedoms of a data subject, which is the individual, should there be a breach of their personal information. And that must be done without undue delay or if feasible, within 72 hours. So there must be a risk impact assessment at that time as well. And the GDPR has wide-ranging implications for SMEs, that's small, medium enterprises and large-scale organizations. And that applies internationally to those organizations, including the ones from Canada, that have, for example, e-commerce businesses or process any personal information of EU data subjects. So it's quite potentially broad. And it's important for Canadian organizations or organizations outside of the EU that might be impacted to seek legal counsel, both domestically and potentially counsel from the EU in the appropriate location or jurisdiction in terms of advice on how to ensure compliance with the GDPR because the penalties are so great.
And keep the business safe ultimately and your customers.
Correct.
Okay, look, it sounds to me as if you're going to be very busy for the next few years, but good luck with that. And thank you so much for joining us and telling us all about the work of Bell Temple LLP. Katherine, thank you.
Thank you.